Yes, I mean, you have to treat, when I get a case, I'm trying to prepare every time like I'm gonna have to try it someday. But you prepare for war and pray for peace, because if you have a trial, there's a lot of risk in it for your client. For instance, you might win the battle, lose the war. You get a lesser included conviction than what they were charged with, but then when the sentence hearing occurs, the judge could give them more time than they were offered by the state on the front end. So you're really trying to protect your client from the system, but also protect them from themselves. Sometimes they don't understand the inherent risks that can happen from going to trial. I don't mind a trial, just like I don't mind settling it. I tell the client, look, it's not a good deal unless you think it is. But if you roll the dice and have a trial, I don't have that risk, you do. So that's one of the things to think about. You get better trying cases once you've tried several. You become a better trial lawyer once you've done some appeals, because when you do an appeal of a verdict, you realize the things you're doing in real time during the trial, you have to do those things timely in order to preserve certain issues on appeal. But if you sort of do your work early, prepare in your investigation, prepare in talking to all the witnesses, prepare with your client, you ought to know within a reasonable degree of certainty how that case is likely to turn out if you go to trial. It might not be where they charged or indicted, it might be some lesser included offense, but you know what the exposure is. And you're able to make those legal or factual arguments to the assistant district attorney and say, well, they're charged or indicted here. I think the proof would be here. What if we reach a reasonable resolution here? And most of the times I've found that the DAs, at least in Sumner County, are fairly reasonable to do what they think is doing justice and what's fair under the circumstances. Again, it's one of those things where if you've tried cases, you're not afraid to try a case, then you're more likely to get a settlement and get a good offer. If you've never tried a case, then it's difficult to get that same good offer, because there's no fear in the DA's mind that, well, they're going to actually take this to trial. They're going to make me do the work, or I might lose the case. There's no guarantee outcome of a trial. I mean, a DA would tell you the same thing. It's a little bit unsettling when you know the fate of your case is in the hands of 12 people that are on jury duty. You just don't know. And I think juries do a good job trying to take their role as a juror seriously, but you just don't know what they're going to like or dislike about the facts or about your client and how a verdict may turn out. And so that can be very unsettling as the defense attorney or the prosecutor, but especially for a defendant. And then if there is in fact a conviction, even of a lesser included offense, then there's the uncertainty of how is the judge going to sentence somebody at a sentence hearing. So I always say, hey, a bird in the hand is worth two in the bush somewhere. You can lock it in. Jeopardy attaches when you enter a plea to something less, and you know, I can take this to the bank. I'm pleading this charge with this punishment, and that's what the deal is, as opposed to just a crapshoot roll of the dice and you don't know what's going to happen when you have a trial.